All right. So with that introduction, welcome to Las Vegas. On behalf of NADA, I want to very sincerely thank you all for being here. As much as we love Zoom and Teams, human beings are better. And it's been 2 years. Last time we were together was actually Vegas. We were talking to someone earlier from the show department, and we were the last real show to be able to finish in 2020. I think the very next one after us had to end early, and we're one of the first ones back. So we've been in some ways very blessed, even though we were apart last year and virtual. But it is wonderful to have everybody back in the room in person. And again, from NADA's perspective, this session in particular, I just want to say thanks for not only coming here, but for coming to Las Vegas, for participating in the show, and frankly for all that you all do for dealers every day. Because we're dealer advocates. We work 24/7 to help our members, and we know you do too. Even though you're driven by your business purposes, increasingly we're all in this together, and we're going to talk about a lot about that today, in particular with respect to some of the regulatory issues coming down the pipe. So I'm joined today by Don Cardinal, and you'll hear from Don a little bit later, so you won't have to hear from me speaking the entire time. And we will have some time for questions, hopefully at the end, and we welcome any questions that you have. But I wanted to take some time this morning to go through some new, newish, but now upon us, regulatory obligations that are coming onto dealers and are going to flow through to the vendor and OEM community. They just are, and I'm going to walk through why that is. And we never want to spring things on people. We don't want to have people asking later this year when you hear from all your dealers at once, why is NADA telling them to do these things? Well, because the regulations are requiring dealers to do these things. So we're putting out some very detailed guidance for dealers about how to comply with some of these rules, and they are going to flow through to you. So that's one of the main reasons we wanted to invite you here today. So in some ways, I'm sort of a messenger with a little bad news, in the sense that there's going to be some work for you because of what the federal government has imposed on dealers. And overall, I think it will be a good thing in the long term, even though there will be some short-term pain, because at the end of the day, we're talking about protecting our consumers and, frankly, protecting our industry. Because if we're not able to swim in the sort of the deep waters of data security, we're not going to make it long term. We just aren't going to live and be able to give people the experience they want, and we're going to be overtaken by regulations and events. So with all that in mind, I do have to give the little disclaimer. I'm going to talk a little bit about some legal issues. I'm an attorney with NADA. I should have introduced myself, Brad Miller. I'm the Chief Regulatory Counsel of Digital Affairs and Privacy. That's my title at NADA, which means I work on a whole variety of data security and privacy issues, mainly on the federal level. I do touch on the state stuff, and we'll talk about some state issues today as they increasingly become de facto federal standards in terms of privacy and some of these areas. But I'm not giving legal advice, and we're not obviously not your lawyers, so we do have to give that disclaimer. So very briefly, I'm going to talk with you most of the time today about what's been happening in Washington, D.C., in particular the safeguards rule, which is the big new rule that everybody's wrestling with this year. But I will touch on some other things that are bubbling up at the federal level. We'll touch on some state issues, a very quick NADA update, and then, like I said, we're going to talk with Don a little bit about his experience in the financial services world and how that might apply to our world. So, all right. I'm a pointy-headed lawyer. I got to start with a little legal background, just so you guys have this in the back of your mind. Some of you may know this, but if you don't, this is sort of an important baseline as you go forward. Okay? The United States does not have a federal data security or privacy law of general applicability, right? We don't have GDPR like Europe does. We don't have anything that says here's the rules about privacy and data security for everybody. What we do on a federal level is we address sectors, right? So there's COPPA for children's data, there's HIPAA for health data, and then there's GLB, which is those three gentlemen there, Mr. Graham, Leach, and Bliley, for the financial services sector. Well, why we're dealers? What are you talking about? Well, dealers are financial institutions under this federal law. That's sort of the hook that brings us all in under this rule. Dealers are financial institutions. Dealers have been regulated since 1999 when this was passed, and 2003 when this rule came out. They're regulated entities under this rule, which means they have obligations, sort of two sets of obligations. There's, on the one side, there's privacy obligations saying, here's who you can share the data with. And that becomes an issue when we talk about data sharing agreements with our OEM friends, or things that we can share with the vendors, and contract terms that have to be in those contracts. Then there's the other half of the equation we're going to focus on today, because that's where the changes have been made. That's called the safeguards rule. And that means, okay, you've got this sensitive data. Now, how do you have to protect it, right? For 20 years, almost 20 years, we've been operating under this regime. Dealers have been subject to this rule. But the rule has been flexible, okay? It says, basically, you have to take reasonable steps to protect the data you have. Well, that seems okay. Take reasonable steps. Depending how big you are, how complicated it is, how sensitive the data is, then you have to take reasonable steps. Well, essentially what has happened over the last few years is there have been, as you know, a lot of high-profile data breaches, right? You get Experian and Uber and all these people that, and the FTC has responded by bringing enforcement actions under either GLB, which you see there, and then at the bottom, the other piece you need to understand is their other source of power at the FTC, which is called Section 5 of the FTC Act, okay? I know I'm getting into legalese here, but this is important because it's basically their federal UDAP authority. I don't know if you know that term. UDAP stands for Unfair Deceptive Acts or Practices. There's a lot of state UDAP laws. This is the federal UDAP law. So basically, even if you're not a financial institution, they can come after you saying what you did was unfair or what you did was deceptive. And so they brought a series of enforcement actions against a lot of companies, a few I mentioned, there were Experian, Uber, TaxSlayer, a whole variety of companies over the last 5, 8, 10 years, saying, you had a data breach. What you did was a UDAP violation because you had a data breach, right? It's almost like 20/20 hindsight. We're going to come in after the fact and find something you did wrong and bring an action against you. Well, the company started pushing back and saying, well, wait a minute, I thought I was doing what was reasonable. How can you say I'm violating this when what I did, I thought it was reasonable? What's reasonable? And frankly, the FTC started losing a few of these cases at the district court level. And so they said, we better tighten this down. And they said, what is our tool to tighten this down? Well, it's the safeguards rule, right? So Congress didn't tell them to do this. This is all on the FTC's own authority. It was controversial, as we'll see in a minute, because it was a split vote. Most of what the FTC does is unanimous. This was a split vote. But they said, we're going to revise their safeguards rule, and basically what we're going to say is, rather than do what's reasonable, you have to do all of these list of 8, 10, 20 things. And basically, it's a list of all the things we made all these people do in these enforcement actions, right? So it doesn't matter. You don't have to do an analysis whether these things actually help with data security. You just have to do them if you're a financial institution. So there's a long prescriptive list that we're going to talk about in a minute. You can see this came out in 2019. We submitted a number of comments sort of saying, hey guys, this is going to be really expensive. This is really hard, and you don't really get that much data security bang for your buck. What are you doing? Can you please be a little bit, the FTC, this is elections have consequences, right? The FTC, for those of you who don't know, is a commission. They have 5 commissioners, 3 the party in power, 3 the party out of power in the presidency. So now we have 3 Ds and 2 Rs. The Ds voted for this rule and the Rs voted against it. So this was a partisan sort of split. You can see Rebecca Slaughter, who's a former Schumer staffer. You got Mr. Bedoya, who's, I believe, is still in the process of he's anticipated to be confirmed soon, but he's a Georgetown professor. Lena Khan is a very aggressive antitrust enforcement lawyer. So they've got a little bit more of an activist group, and they passed this rule, and even after our comments, they issued the rule finally in October of last year, so late October. So the rules, and they published it in the Federal Register on December 9th. That date's important because you have to comply by 1 year after they publish it. So the deadline for compliance is December 9th. What does it do? Okay, and at 30,000 feet, it abandons that, as I said, abandons that reasonableness standard, and it says you got to do all these things that we're going to tell you have to do. By the way, you may have to do more if it's reasonable to do more, but you have to do at least these 18 things we've told you to do, right? You have to comply by December 9th. There is an exception if you have fewer than 5,000 records, but it only gets you out of a few of the duties, and frankly, I don't know that any franchise dealer is really going to be in that bucket. I could be wrong, but I don't think so, because there's one more piece that I need level set you all in this room about, because it's increasingly important. Even for those of you who know about GLB and know about safeguards rule, you probably also know that technically the rule applies not only to financial institutions, but only to a certain type of data that they keep called non-public personal information, right? But the FTC has really taken a very, very broad view of what is covered under this rule. To the extent that our advice to dealers is basically you have to treat anything that identifies a customer as if it were NPI, non-public personal information. So there may be an argument for someone if they want to, if they have an enforcement action or get sued, they can say this doesn't apply. But from everything that the FTC has told us, we submitted, they answered a lot of our comments. We asked them, I'll give you an example. We asked them a question, what if the dealer just has, deletes all the information but the name, the address, and the VIN number of the car? And they said, well, that's still customer information that's covered by the rule. So RO information, employee information, any information they get, it's not just, a lot of dealers still think, oh, it's just social security numbers, credit cards, or some subset of sensitive data. That's not the case. It's any personal information a dealership has. They really have to make sure that it's meeting all the requirements that I'm going to cover in a minute here. So that's essentially what it does. Again, we're going to go through this in more detail. You got to have some technical changes, tools, policy changes. You got to have some documents the dealers are going to have to do. We'll go through all of this. And I mentioned those bullets. You see the enforcement penalties are higher. Look, I'll be frank with the folks in this room. There have not been a lot of lawsuits to date under this rule, which is one reason in my mind, it's been a little sleepy, because there's no private right of action directly under the GLB. So in other words, someone can't sue you directly saying, I'm suing you because you violated the safeguards rule. But not only are the enforcement penalties higher, and we think enforcement activity is going to increase, but increasingly what's happening is state law claims are being brought against dealers with the underlying federal UDAT violation as the claims, cause of action. So in other words, they say, you violated the safeguards rule. I can't sue under federal law, but I'm suing under state law in a class action because of your federal violation. So this is in the weeds stuff. My point to you is this. The plaintiffs' bars are becoming more successful in suing people when there's a data breach, and one of the first things they're going to do is look at safeguards compliance for financial institutions like dealers. So I think the risks are increasing. Okay, so before I get into the details of the requirements of the rule, this room I wanted to share one thing, and again, this is just me sharing with you. I'm not your lawyer. I would check with your lawyer. You may want to flag this issue. But one change that's sort of buried in this rule is they not only have made all these new obligations on financial institutions, but they are seeking to expand what a financial institution is. Now again, whether this is valid under their legal authority or not is an open question, but under this concept of finders, they basically have expanded the definition, as you see, of financial institution to include entities significantly engaged in activities incidental to financial activities. What does that mean? As you can see, there's an example of bringing together one or more buyers, but here's some other examples. Sorry for the font, but here's some examples they gave. Identifying potential parties, making inquiries as to interest, introducing and referring potential parties, etc., for expressions of interest, bids, offers, orders, and confirmations relating to a transaction. So what does that mean? I'm not sure, but it sounds to me like they're suggesting that anybody that's involved in lead generation, in putting a dealer together with a consumer who finances a vehicle, or does some other activity that could meet some of these definitions could be deemed a finder, which means you directly would then therefore be responsible for compliance with the safeguards rule. So again, I throw that out there because it's sort of a buried little issue. If you're a vendor or an OEM that is engaged in any of these things with dealers, right, where you are putting consumers together with dealers that ultimately finance a vehicle, you could be pulled in under this finder's expanded definition. So you could be directly liable for compliance with the safeguards rule yourself. Something to think about. I don't know. I'm not here to opine on that. I have opinions on it, but they're meaningless. It's what the FTC thinks it is, not Brad Miller. So with that in mind, let's talk about some of the new requirements very briefly. And again, we've got a guide, just so you know, even though our guide is for our members, and I should have checked, but I'm not sure if it's available to folks who are not members. I'll look into that. But we've got a comprehensive guide that's coming out tomorrow, that we're issuing out to all our dealers tomorrow. It'll be available actually at our booth to dealers. So my point in telling you this is we're going to hear from dealers. We're going to be giving this to dealers. It may be on top of their mind today. They may be talking to you while they're here at the show. So yeah, I can answer a question real quick.
Before you go into
I think they said no pictures, but I think the slides will be available. So yeah, the slides will be available. So yes, thank you. So let's talk about, we're not going to be able to cover these in depth, but this is just an idea of what dealers are going to have to do by December 9th. And also, and again, I'm going to get to this in a minute, also what in large part you are going to have to do by December 9th for a dealer to be able to do business with you, to share their information with you. So they have to appoint a qualified employee. So we're not sure what that means. I can tell you one thing that they changed in response to our comments, the FTC. This originally was going to be a CISO. Every dealer in the country was going to have to hire a CISO. I said, that's crazy. We can't do that. So at least they changed that from a CISO to a qualified employee. But they're going to have to appoint a person. They're going to have to do the written risk assessment, all these things. They have to do a data and systems inventory. What does that mean? That means they're going to look at all of the systems that they have that store or could store consumer data. Okay? So if you're a vendor or an OEM or someone that has any consumer data that touches the dealership, they're going to be asking you a lot of questions about what you have and where you have it and with whom you share it. So they need to have full insight into all that information to do this inventory, to do then they do, once they figure out where it all is, they have to do a risk assessment based on the risks of that data, knowing what the data is and who has access to it and et cetera. So it's kind of a complicated situation. But they have to encrypt data at rest and in transit, as do their vendors. They have to enact multi-factor authentication, as do all their vendors who touch the dealer systems. So some of these apply directly to you explicitly in the rule. Some of them just apply because the dealer has to oversee you and ensure you have proper safeguards. So we'll talk about that in a minute. But they have to do all of these things by December 9th. Again, why should you care? And I'll get to your question in 1 second. But this is the key slide if I'm in your seat, which is even if you're not a finder, and I talked about the finder thing, that you could be directly responsible. But even if you're not, here's what dealers are going to be asking for from you in the next few months so that they can comply by December 9th. They are going to require you to directly comply with many of the requirements in the rule, and they have to get that by contract with you. So you can expect some new contract terms coming. They need full disclosure of the data accessed and with whom it's shared. I just talked about that. There's probably going to be an InfoSec questionnaire, some sort of questionnaire that they send to you so that they can verify you're doing the things you're supposed to be doing. You have to guarantee you're undertaking secure development practices if you develop any software that touches the data. There's actually a deletion requirement. So the FTC has gone so far as to say that a financial institution, if they don't have a legitimate business purpose, whatever that is, to hold the data more than 2 years, they have to delete it, no later than 2 years. So you may start hearing, if you haven't already, hey, please confirm for me that you've deleted this data either immediately after use or no later than 2 years, etc. We'll talk about this too. They also need to undertake an IT audit of all their service providers. And a third-party certification is not enough, according to the FTC. Direct IT implementation requirements, and again, new contract terms. We talked about this stuff. So all of this by December 9th. I can tell you I've done a number of sessions for this for groups of dealers, and the first thing I say is, today you have to appoint the person in charge, the qualified employee. First step is reach out to your vendors and your OEMs, because this is a big undertaking, not just for the dealers internally, but for all of you in this room, and I know it's going to be. So you know, from where I'm sitting, it's a big ask, and you know, I'm sure you're sitting there thinking, well, shoot, I've got 4,000 dealers or 1,000 clients or whatever it is, and I'm going to be getting this hit from all directions. And so we'll talk a little bit about what we're trying to do to make this a little bit more efficient, but make no mistake, I think this is going to be a relatively heavy lift over the next year. I'm sorry about the font here, but I just wanted to give you an example. This is a quote from the rule, just to show you what the kind of thing they're saying, and I'll read it. It's hard to read, so I'll read some of it. But when a vendor accesses the financial institution, in other words, the dealer's data or information system, the dealer must ensure appropriate access controls are in place and for themselves, right? And separately, the dealer must reasonably oversee the vendor's safeguards, which would necessarily include access controls. So they're going to be coming to you and saying, I've put proper passwords in place, I've segregated the data, I have whatever access controls I need. Please confirm that you are doing the same and tell me what those controls are. So that's just one example that I pulled straight from the rule that give you a sense of what the rule's telling dealers they have to do. Again, we talked about this, but they got to do this data and systems inventory. So again, first step they've got to do once they appoint their person is figure out where everything is. And what we tell dealers in the guide is they got, this is out of the box. This is anywhere that it could reside. The car, salespeople's phones, if they're calling customers in the front end, not just the DMS and the CRM and the websites, and not just dealer websites. It's OEM websites. Wherever this consumer information could reside, dealers need to understand that picture and have that, and they got to write all this down in this report. So they got to identify all this stuff and then start assessing the risk to that data once they've identified it. So again, we all know dealers rely on vendors and OEMs for all sorts of technical help. So they're going to be coming to you and asking these questions as they will need to do. So again, these are just some examples. Again, here's some of the technical requirements. We talked about this. Dealers must implement encryption at rest and in transit. I'm not 100% sure what that means because it could be clarified, but certainly it means as it's coming back and forth from them to you and vice versa. MFA, we talked about that. Systems monitoring, pen testing. There are some options to pen testing, although some of them may need to do that. And that's going to be a brand new thing for most dealers, I think, and that isn't cheap, as we know. Vulnerability assessments, those kinds of things that, look, each of these individually are fine. They're not bad ideas, right? But doing all of them all at once for every dealer in America is a crazy amount of overkill in many ways, but it's what's coming. So again, and you must ensure the vendors adopt these things as well. And as I said, some of them are very explicit, like encryption, MFA. They say you have to do it and all your vendors have to do it. Access controls, you have to do it and all your vendors have to do it. But some of them are more implicit in the sense they say you have to do it and you have to make sure that you've ensured that your vendors are doing appropriate things. So it's a little unclear where some of those lines. Now what about the people you subcontract with, right? So you've implemented encryption. What if you need to share it with a subcontractor to do what you do? We asked them that question, and they didn't really answer us. But it certainly seems to me reasonable to suggest that whatever restriction that they put on you is going to have to sort of push down the line to anybody you engage to help you do what you do. So again, I know I'm like a fountain of great news, but this is what's coming with the new requirements. So again, this is quotes from the rule. This is what dealers have to do with their service providers, and service providers is anybody who touches dealer data. That's sort of how they define it. Okay, so if you're touching the dealer data to provide the dealer service, you're clearly a service provider. But I think in some ways it's broader than that. So dealers have to, before they engage a service provider, I don't have to read this for you, but they have to take reasonable steps to select and retain them. So what does that mean? I would assume that means at least some sort of SOC 2 compliance, whatever you can show them for just the basics, some experience, some systems basics for what you can do, some secure development practices. And then they're going to this is probably one of the biggest things that I want to make sure this room hears. They have to amend their contracts with you. So you're going to be seeing, in fact, we're working right now on some sample contract terms just to make life a little easier. It's not to impose something on those of you in this room, in the vendor community, the OEM community, that's unreasonable. It's because the rule is requiring dealers to do this. And they look to us for help, and we can't give them legal advice. But hopefully our view is getting some standardized terms will at least make your life easier in the sense that you're not doing this 4,000 times, right? Or 1,000 times or 500 times. So be on the lookout for that. I do want you to know that it's not in our guide yet because we want to make sure that we're doing it right and we're meeting all the antitrust hoops and all that stuff. But we are going to be issuing some of those things for dealers because they need some help in this area, and they have to do this. So this is going to say things like you agree by contract that you'll implement the following safeguards. And that you'll do the following things with data that you obtain from my systems. And then they have to periodically assess that you're doing what you said you did in the contract. And what does that mean? As I said earlier, and I'll skip over this, but we asked the FTC this question, and here's a quote from the FTC. Certifications, reports, or third-party audits may be appropriate, but they declined to adopt the suggestion to allow the dealer to accept an information security certification to satisfy this requirement. So it's not enough just to give them your SOC 2 compliance or your PCI compliance. It's going to require the dealer to do something else. And that's some kind of third-party audit is sort of what they seem to be suggesting. Now again, this is an area where, in our view, if this is required, and we think it is, it makes some sense to think about working as an industry to see if we can find a way to meet the requirements without having you do this 8,000 times or 1,000 times.
There is a precedent for that. Financial services, we got together, and we have several vendors that are common, like Harlan Clark, prints everybody's checks. Well, if every one of their customers decided to audit them, they'd be 3 deep auditors every day of the week, including them. So they threw up their hands and please, get together, gang audit us once, write the report, you all agree to accept it, and we're done. There are 2 companies out there that do those common audits, and they've agreed to accept it. And so the financial services industry has solved a lot of these issues, but industry-wide audits are a real thing. Been doing them for years.
Yeah, so it's, look, it's and certainly one of the things we'll be talking with Don about is sort of what their experience has been, because they've been on for it a little bit before we have. Make no mistake, the regulators are sort of seeking to treat dealers the same way that, think about your bank. When you log on to your bank website or your credit union and you go through the MFA and the security you expect from there, that's essentially what they're trying to translate to our world, which is hence why we're talking to Don, is becoming appropriate. Okay, so lastly, again, I'm just giving you some other quotes that, this is me saying, hey, look, this is NADA, this is not NADA coming and trying to bring the hammer down on vendors. This is the FTC bringing the hammer down on all financial institutions, and the reverberations are sort of coming through to you, right? I mean, we made, I didn't mention this, but we made, in our comments, I'm going to give you some sense of the scope of this. We did a study 5 or 6 years ago where we had a company come and look at the cost of all federal regulatory requirements for dealers, just federal regulatory, not related to the car, just what dealers have to do to comply with federal regulatory obligations, which is a lot. It's about $186,000 a year the dealers have to spend to comply. This alone, we did a cost study with an IT firm. They suggested it would be about $300,000 the first year for dealers and about $300,000 a year thereafter for the average dealer to comply with this. So that gives you a sense of the scope of the cost of this, and we of course made that point to the FTC. Their answer was, well, yes, while there will be some burdens on the service providers, these are necessary burdens. And the financial institution must be sure the service provider is protecting the information, and any expenses this involves are a necessary part of fulfilling this duty. So pound sand, right? If it's expensive, I'm sorry, but you've got to do it. So that's kind of what they told us. And lastly, we said, okay, what is the dealer supposed to do if the service provider can't or won't do what they've asked? Here's our quote. If it's infeasible for the service provider to meet these requirements, then the financial institution's qualified individual, that's the person in charge, must work with the service provider to develop compensating controls or cease doing business with the service provider, right? So I don't know that you want to be working on compensating controls with all your dealers, but a lot of dealers are going to look at that and say, look, for me to do business with you, I need to get all this done. So it is not a light burden with which we share all these things. Okay, so I'm sensing the room. I know this is like a lot of bad news bringing you down, but I really do want I sincerely just want you to understand this is why we have this session. I spoke to a group yesterday. There was a lot of dealer and vendor folks in that room as well. There's an organization called STAR that works on this issue of standardizing these things across the industry. We're working with them. We're trying to do the right thing to make this as efficient as we can, and that's why we're really reaching out to you all to let you know why this is coming, and then maybe the next step is we can talk about how to make it more efficient. So again, InfoSec questionnaires, all these things are the things you're going to be expecting from dealers in the coming months, because they've got to do this really, frankly, as an initial matter. I've sort of said in the next 2 or 3 months, so that they can then do their internal processes they have to do over the fall to be ready by December. So this is coming soon from dealers. Okay, so I feel like I've just thrown a whole ton of bad news at you all. I'm just letting you know that we have put out some guidance on this stuff. There's this FAQ we put out like a week after it came out. It's got some good information. It's still available out there in the world, probably to you. And the guide I mentioned as well, again, to me, this is important to you because the timing is we're putting it out now. You may be hearing about it here at the show, and I wanted to let you know why. Also, it's got some sample stuff in there, some sample, all this stuff at the end of the day from the dealer perspective. One of the big things they have to do is then put all this stuff in their writing. So they have to have a written risk assessment. They have to have a written information security program. They have to have a written incident response program. They have to do a written report to their board or their leadership. So they have to have all these written documents by the end of the year. We've given them some templates for that in this. and we're going to be doing the template on the contract terms. So again, this is relevant to you in the sense that, this is why this is all of a sudden coming to me from all my dealers, is because NADA's guide came out and now we're starting to hear this stuff. So it's coming out soon, and you may expect to hear more about it shortly. So that's a good breaking point. That's the big news of the day. Obviously, there's a lot more to it than that, but this is a pretty big one. And we're not often chicken little on this kind of stuff. We don't sort of say the sky's falling on these things, but this is going to be a tough one. Yes, sir.
Yeah. So you mentioned risk assessment, and I know there's a lot of different people claiming they can do risk assessments, and they include different things within that assessment.
Right. Sure. And the question for the recording is sort of, what does it mean to do a risk assessment? What do you have to have in it? How can you do one properly? And the answer is, it's unclear. I mean, what they've done is they've given you sort of 3 categories of things the risk assessment has to address, and then 8 specific issues you gotta talk about in your written document, right? So they've given some sort of framework of the guide of what you have to include in there, but they don't say, it's not, as much as they've sort of given you this prescriptive list of things you have to do, they haven't exactly said how you do each of them. So there's a lot of questions like that remain unanswered. I hope that the marketplace will go forward. Look, my take on this from a dealer perspective is, we have a lot of dealers who do a pretty darn good job with this today, but I don't know many who are doing all these things. And there are a lot that aren't doing many of these things. So this is going to be a very big lift for especially smaller dealers, let's be frank. So we're trying to give some options for dealers. Our hope is the dealers will at least get the basics done so they have something, right? And then they can work, because it's ongoing too. I mean, it's not just once. You have to continually, you have to update your programs, you have to annually report to the board. This is an ongoing obligation that it will be with us forever. So hopefully we'll keep getting better over the years. But the answer is, we don't know for sure right now. Now, again, we're not leaving them blank. We've given a template that I think will be a guide for a lot of people, because it's very comprehensive and it's pretty good, I think. It's as good as you can do with what they've given us. But you're right. We face this issue all the time. What's enough to be in the contract, right? That's always an issue. What's enough to be a risk assessment? What has to be? And there's no clear answer. And so, we're not trying to force everybody in the same bucket, but we're trying to, I'm going to make this plea again and again. The more we can sort of get everybody together and say, yeah, that's reasonable and that meets the requirements and that makes life easier, then hopefully that'll make everybody's life a little easier, dealers, vendors, OEMs, and everyone. So, good question. Yes, ma'am.
The 5,000
customer.
Yeah.
Yes.
Is that per group or per individual?
The question is the 5,000 limit per group or individual dealer? It's basically, it's a little complicated, but basically it's per entity. If you're a legal entity, if you're 6 different C corps all owned by different people without common control, then it's probably each dealership, but it's sort of a common control issue. I mean, I can tell you the average dealership last time I looked had by a factor of 10 or 20 more records than that in their systems. So it's going to be interesting. Yes, it's any customer records that you have custody control basically of, right? So it's not just files sitting in a file cabinet at your store. It's anything that you have custody control in your dealer systems. So look, and at the end of the day, the reality is that exemption only gets you out of a few of these. Of the 18, I think it gets you out of 2 of the requirements. So it's really it's not all that helpful anyway. Unfortunately, I'm not trying to downgrade it because we asked them to do it. Although we asked for 50,000 records and they gave us 5. So yes, sir.
Do you expect the FTC to potentially provide more clarity on the definition of customer data? That's even broader than GDPR.
The question is, do we expect the FTC to give more definition on what is customer data? Because it seems very broad, and the answer is yes, it's very broad. I mean, look, they have taken, again, I'm opining here. I'm inserting my Brad Miller opinion here. I think they've gone well beyond their statutory mandate, but on the other hand, it's politically, this is a bipartisan popular issue. Go after this horrible data breach thing. So there's not a lot of controls until someone sues them and a court says you've gone too far. They have been very clear that they consider any record. The best example is the one I gave. We said, what if a dealer just keeps name, address, email, and VIN number? And they said that's a customer record that that's enough to make it a customer record that you have to protect. So, and they've defined that very broadly in some of their enforcement actions and elsewhere. So, it's the lawyers in the room or the lawyers at your shops will come back and say, any day is full of blowing smoke. It's not that broad. If you read the statute, that's probably true. But if you read what the FTC says and what the position they've taken, it's certainly broader. So their opinion is more important than mine. So it's a good question. And again, it's always been an issue for dealers. How do you, when you have a name, it's this, I could bore you with this, but this very strange thing we've been living with forever. Because we're a financial institution, we're not a bank, right? Most banks, all the records are non-public personal information, are all this sensitive stuff. But because dealers do some cash deals, we have service customers, we have some finance customers, we live in this weird world where some of it's MPI and some of it isn't. But if I come in and I say, I'm Brad Miller, here's my email address, and I just tell that to the salesperson, that's probably not MPI. But if I put it on a credit app, it's MPI. And so in the system, you can't really determine, you can't distinguish anyway. It's always been a very difficult thing for dealers. So there's almost no way to automate the distinction anyway. And so we've often said that you really have to take a broad view as a dealer just because we're in this weird situation. So that's a good question. So any other questions on this? And we'll take more, but I want to talk about a couple other things. And I always got to make sure if I don't check, I'll just keep talking. Okay, so I'm going to talk about a couple of the things that are happening at the federal level that I thought you all might be interested in because they could affect us. Anytime the FTC comes out and says we're interested in this issue, expect enforcement actions and something to happen in the next few years. So we don't want folks to be caught by surprise. So we're going to talk about a few issues. One is algorithmic and biometric bias. If you don't know what this is sort of the theory that somehow the algorithm that makes an AI decision or some sort of decision, especially in the context of financing or obviously employment or something that's legally protected, could have some inherent bias in it so that you end up violating one of these three, either Section 5 of the FTC Act, the Fair Credit Reporting Act, or the Equal Credit Opportunity Act. And you see some of those there. These are the specific statutes the FTC has cited as potentially being violated by a biased algorithm or biometric selection of consumers. In fact, they went so far, you see this is dated September of last year, to show you sort of how aggressive the FTC has become, they've instituted this what they call compulsory process resolutions. This hit our industry in another area. They send a letter to like 600 companies and just say, we think you're likely violating this issue, and if you don't start, turning it around, we're going to bring an enforcement action against you. Because, again, I don't want to get in the weeds, but their authority under Section 5 to extract a monetary penalty from you is limited to saying you violated it, so here's your consent order, and then if you violate it again, then they can go get money from you, right? Well, what they've done is they send these letters to 600 people so that next time they just go after you for money, right? They want money damages, and they don't have the authority always to do so. So this is, and my point in saying this is, you see it's 8 key enforcement areas. This was one of them, biometric or algorithmic bias. So again, and Bedoya, who I mentioned, who's the nominee who's coming in, this was his specialty as a professor at Georgetown. So he's very interested in this issue. So again, these are all sort of flashing red lights saying something's coming in this area. And guess what? The font got messed up. I'm sorry. But this is in our world. This is in the dealer world. This is just an example. I don't want to pick on a vendor, but purpose-built AI platform that allows dealers to create private offer marketing campaigns that enable OEMs to offer branded messaging and incentive dollars, right? So you're using AI to say, I don't want to just give an incentive to anybody who comes in. I want to give it just to Brad Miller or just to Joe Smith or just to Mary Smith. That is where it gets problematic because if they look at that after the fact and say, well, that algorithm resulted in only this protected class getting the offer and not this protected class, you could have an issue. So they're flashing the red light on this. Just I want again, my interest is making sure dealers don't get caught in the crosshairs of something unintentionally, but obviously the vendor world as well and the OEMs. And here's another one. If you haven't heard of, you should at least know what dark patterns are. This is like a hot button issue amongst the privacy bar and the law and the law professors out there. it's essentially, the theory is that you're using this manipulative technique with text and flashing lights and colors and everything else to manipulate people into doing something they don't want to do, right? The I accept button is really big and flashy and has smiley faces, and the decline is over here with, in brown and hidden, right? So this is a big issue for them. Again, there are a few folks at the FTC who have been talking about this for a few years, and they keep, you'll see an enforcement action on this soon, and I don't want it to be in our world. There's also been a lot of executive activity in the right to repair world. If you don't know what this is, it's just something you may want to have in the back of your mind. If you're an OEM, you probably know what this is. If you're in the vendor world, it may be new to you, but this is a growing sort of movement driven in large part by the automotive aftermarket and by aftermarket parts manufacturers who are increasingly concerned about access to data from the vehicle, right? You probably heard about this with, like, farmers want to be able to repair their John Deere tractors and they can't, or people want to fix their Apple iPhones and they can't because you need a special tool, right? That's right to repair. I want the right to repair my stuff. Well, they've taken that in the auto space and said, I want the right to repair my car, which means I need to have access to all the data from the vehicle. That raises all sorts of cybersecurity and privacy concerns and competitive concerns. We think in large part in the auto space, it is more to do with wanting access to the dashboard and marketing than it does to repairing the vehicle. But this is an issue. You see the Biden administration put something out last year on this. There was a report from the FTC. They're getting interested in this issue. Thankfully, largely not in the auto space yet, but it's coming. We can talk about that a lot more, but those are just a couple issues. While you're here, just sort of keep those in the back of your mind. Yes, sir.
Just want to make sure you've seen the official complaints against John Deere last week.
Mm-hmm.
Farmers Association.
Right. The question was, just noting there was actually a lawsuit, not a complaint, I think it was a formal complaint brought to the FTC against John Deere on this issue. So, yeah, and look, this is also one of those politically popular ideas because farmers not being able to fix their tractor has a lot of traction in Nebraska and as maybe it should. But the problem is it doesn't really translate to the consumer light duty vehicle world. Okay, very briefly, there's also things happening in the states, as you know. I'm not going to spend a lot of time on this. You all may be aware of this, but obviously California leading the way. We had CCPA a few years ago. For those of you who don't know, there's a new iteration called CPRA, which starts in next January, which is even more onerous. I have heard that in California they've set up a state agency to be the enforcement agency. I've heard that one of the first enforcement actions was actually against a dealer, oddly enough, and wasn't sort of like for the low-hanging fruit kind of thing. It was like really in the weeds, and it has to do with basically what information they're sharing with third parties. So. Just for what it's worth, that is creating issues, in particular for my OEM friends in the room, in terms of agreements between dealers and OEMs to share data back and forth. This has become an issue, and I'm not sure there's even really a great consensus yet as to how to deal with it, because there are implications. Are you selling data? What kind of opt-out rights and tracking do you have to have? How do you do that with the dealer world? So this is creating issues. Virginia, Colorado, and for those of you who don't know, just last week Utah joined, so now we have a fourth state. There are a few others I am aware of. There was one in Florida in particular that was particularly interesting because it had a private right of action, which would really change the landscape. In other words, if people can't sue you directly for violations of this, it would change things very dramatically quickly, not for the better. And I don't think it would be good from a consumer protection perspective either. But that I understand is a little bit unclear whether that's going to pass. Massachusetts, New York, some others. So expect more. This is a burgeoning area. We're now going to get this patchwork. And so just be aware that this is going to have implications for whether we can share information with each other. For this room, I just wanted to point this out. This was an interesting little thing buried in the Virginia statute, talking about, and it goes to the question that the lady had earlier about what it means to be a legal entity. They actually defined an affiliate in Virginia to include, as you see there, someone who shares common branding with another legal entity. The upshot of that, interestingly, is arguably sharing with the manufacturer between the OEM and the dealer is not sharing under Virginia's statute. So it's an interesting concept, just something to think about with my OEM friends in the room as these go forward. and we are trying to continue to work together on how to address this and get information back and forth so the consumer's best served. Maybe we want to think of some sort of a framework where it's really not deemed to be sharing. It's between the two of us. So it's out there. Again, I'm going to go quickly because, as always, I'm taking more time. But these have a lot of the same implications that the safeguards rule does, right? I mean, are you selling data? There may be audit rights imposed. There's going to be contractual requirements that are coming at vendors and OEMs because of these state requirements. I mean, CCPA requires provisions in the contract about what you're doing with data. If I shared this information with you, you have to promise me by contract you're going to not do X with it. And that's going to be in the contract. So these things are coming if you haven't seen them already. Lastly, there was a bill in Arizona that has some relevance to those of you in this room. It was passed unanimously by the Arizona legislature a few years ago. There was a lawsuit challenging the legislation, and we'll talk about how that came out. But basically, it's an interesting statute because it's basically, I think the theory of it is it's to really try and let sort of 1,000 flowers of innovation bloom with respect to how this information is stored and shared and protected, and some of the things that Don's going to talk about in a little while, because it's, the dealers went to their legislature and said, we need a law because we're trying to do some things with this information and we can't do it for whatever reason. And so it prohibits third parties from keeping dealers from doing all sorts of things with the data that they have, with the idea being not, of course, the dealers want to sell it or monetize it, they want to protect it. But they want to be creative in the way that they do it. They want to share it with who they want to share it, but do it securely. It talks about open APIs and some other things that Don's going to talk about. So it's something that I think, if you're not familiar with it, you should take a look at it. As I said, there was a lawsuit challenging it, and the district court ruled against those claims, upheld the law. The Ninth Circuit, in about it's probably been 3 or 4 months. Actually, I think it was 4 or 5 months ago now, upheld the law in its entirety. So a panel of the Ninth Circuit has now ruled saying that this law is upheld, at least on this facial challenge. So it's law as of today. And there are other states, I'll just tell you, now that has happened, it's much more likely other states may follow this approach, because these are pain points that dealers have throughout the country. And so I think this may be something that you'll be hearing more and more about. Okay. Very briefly, and then by way of transition to Don, I want to share one other thing with you this is new, and this is, you're the first sort of see this thing, but NADA continues, and we could have spent just an hour on this because this is an important, I don't want to make light of it, but the safeguards are so critical, I wanted to focus on that. We continue to spend a lot of time working with our OEM friends on agreements to get information back and forth between the two of us in a secure way. And we continue to have a lot of issues from the dealer perspective. But there's a lot of dealer pain on these issues because it's not just the scope of the data. In many times, it's the involvement of a third party in the process, where the dealer doesn't have insight into how that's happening, or may not even see the contract, may not feel that they have a lot of ability to influence that agreement. Because basically what happens is the OEM says, look, we'd like to run a program and we need information from you to do this, and we're going to give you some information. Let's have an agreement so that we can get this back and forth in a compliant way. Well, they will often hire a third party to help them do it, right? And that's fine, except that dealers, unless the dealer doesn't know who the third party is, doesn't see the contract, they end up having to share their data with a third party they may not even have any insight into, and that really does cause pain, in particular for the dealers that are trying to do the right thing. And so we're continuing to work with our OEM friends on a lot of these issues, and we continue to think that there are better ways to do it, and I think that's our segue to Don. But in the meantime, we have issued this document, and we share it with the Alliance, which is the trade association for the OEMs, but it's a set of principles. And it's really just, I don't think shouldn't be too controversial. But we're trying to socialize it at the trade association level and then at the OEM level, really talking about the nature of the agreements between us, the nature of the role of third parties in these data sharing arrangements, and then frankly working together on ways to make this better. Look, this is the segue to our conversation with Don, but I am not, I don't hold myself out to be the world's renowned IT expert, but everyone I talk to says the auto space is getting there, but it's still got a long way to go in terms of getting information. The OEMs are rightly focused on getting the car right. They have to do that, right? Dealers are focused on protecting their systems. increasingly we're going to have to continue to talk with each other, with the car, with the dealership, with the financial institution. People are going to want to make their payments through the dashboard. The need for secure integration is only continuing to grow. And so we're trying to put out these principles just saying, look, the entire ecosystem's got to work together. Vendors, third parties, OEMs, dealers, and others. So that's out there, and we'll take some questions, but in the interest of time, maybe I'll give Don a chance to go through a couple of his slides. If you want to take the con up here and push the buttons. But Don is director, right? Director of the Financial Data Exchange. Financial Data Exchange is a subsidiary of the FS-ISAC, correct?
That is correct.
And for those of you who don't know, an ISAC, Information Sharing and Analysis Center, is a group of competitors that get together and share sort of cybersecurity threat information, right? And there is an auto ISAC, a very active auto ISAC. And so we've got the structure at the OEM and supplier level, and NADA is a sort of a quasi-member of that organization. But really getting dealers into that information sharing and standardization of data flow has long been a goal of ours. And so I just wanted to ask Don to come and tell a little bit about what he does and maybe how it could affect our world. So with that, Don, go ahead.
So I appreciate the time today. So why is someone in financial services coming in and talk? A lot of times financial services is at the forefront of cyber and data sharing, and certainly within regulation. And so they've gotten to be good at cyber, not because they wanted to be, because they had to be. Willie Sutton, that's where the money was. So a few years back, we were dealing with an issue with screen scraping. We're still doing an issue with screen scraping, and I'll get to this API one in a minute. What screen scraping is, if you ever use TurboTax or QuickBooks or Mint or any number of the other tools, they'll say, great, where do you bank? Give me your ID and password. Great, you've just given them full control to every penny you had to your name. What were you thinking? What if you could have that same access, never cough up your ID and password? And what if it were free? Free to the users, free to the apps? That would be pretty cool. Yeah, you just reduce your risk profile and you're not incurring any costs. And what if it was CCPA, GDPR friendly? What if it used best-in-class security? And what if the consumer groups like the National Consumer Law Center and your regulators were happy with it too? That's what we've done. So why we got here, the financial services industry got together to deal with screen scraping. How bad was it at its point? At its peak, there were roughly 100 million ID and password pairs in the hands of tech firms and aggregators. You're one thumb drive away from having a really bad day, one disgruntled employee walking out with that. Now the tech's been around since 1995-ish, so it's been around for a very, very long time. But if you think it's just banks that are being scraped, if you're Hyundai Motor Credit or Ford Motor Credit, I guarantee you 2/3 of the login sessions on your site are not human. Go ask the folks who man that firewall, and they'll tell you. So we decided we better get together and do something about this, because if we don't, the federal government will. Worse yet, 50 states will, and then we'll have to deal with a patchwork of regulations. And when the federal government or any government picks tech standards, they don't do a good job, because they don't own the primary customer relationship and they don't own the end risk. And so without that skin in the game, without thinking about, well, gee whiz, how is this scalable? Those things tend not to work. So we were at this for about 3 years now. We've got about 28 million of those 100 million IDs and passwords out of the ecosystem. We've done it voluntarily, not just with big firms, but small firms as well. But we've improved our privacy standpoint. We have a standardized data sharing format, a standard security model. And it's not just in the US. We're in Canada, but we've also based our standards on what's done globally. And the reason I tell you all this is basically why you should listen to us. We've done this at scale. You see big names all the way around. We're doing this today in production. This isn't some whiteboard exercise. Again, it's met muster across the planet. We do this what we call an API, and I promised it was the only acronym I was going to use in this. So what an API is effectively basically a delivery truck. It's a dedicated interface. So instead of pulling up the front door, I pull up to a dedicated loading dock. They know who I am, what I'm there for, standardized payload. It's really, really important for it to be scalable. One of the things we found is when you start having parties talk to each other, if they all have proprietary connections, if you're a big, then you have to get everybody else to talk to you in that proprietary way. If you're a small startup vendor, especially minority-owned one, and you're trying to talk to all these different proprietary standards, I need dozens of developers just to maintain that connection. And that barrier to entry keeps a lot of minority startups out of the business. It just costs too much. What if you could plug into everybody seamlessly interchangeably like a USB. Wow, that lowers the barrier to entry. That allows a lot of women-owned and minority-owned businesses and vendors to be in the space. Still comply to all the standards, but it allows a lot of other folks, if your DEI is an issue for this industry, and what can you do to lower barriers to entry? Well, common standards do that today. We know that. So that's effectively who we are and what we are, but I want to talk a little bit about why you should care. Imagine if you could do all those things seamlessly. So you have a customer on a lot. There's a car I like, great. Pull up the dealer app. You should biometric to authenticate. I want to buy this. Who do you bank with? Oh, I bank with Wells. Wait, the Wells app launches. Hey, you look like you want to buy a car. Another thumbprint, pre-fills the app, does your anti-money laundering, does your know your customer, and already does your scoring. Full consent. It's time-based. The token expires. There's nothing can be breached. There's no IDs or passwords exchanged. Boom, they're already applied. So there's no waiting for financing, waiting for all it to be done. And it's all available today for free. Can't beat that.
So yeah, thank you. Well, I appreciate that. We wanted to give you a little taste of what they did. And have a seat. Let me just spend a few minutes, and we're open to questions. But I talked to Don, and we're obviously looking around. As I said, we've been working for a number of years trying to find the magic. We're unique in our own ways, but we have the same problems a lot of other folks have. How are they handling it? And so, we were talking to Don, and I just thought it was worth hearing from him and what their experiences are. I mean, Don, you've heard what I said today. I mean, you touched on this, but what you're talking about basically is a standardized API, and I say open. I assume it's an open API,
free of charge,
that people can write to. And for the non-tech folks in the room, what you're saying, and including me, what you're saying is you set up a way to get data from A to B in a secure and auditable way. Absolutely. Am I right? And hearing what I said today, would that have an effect on things like the safeguards rule and
Absolutely,
compliance?
because you can say we use this standard, so it's secure, it's customer permissioned, and it is standardized. And we do have data security standards based for data at rest, data in motion, and data in use. Remember, the firms that built this standard have trillions of dollars in deposit, trillions of investments under management, and trillions of dollars in market cap around the globe. This represents best in class with respect to cybersecurity.
So yeah, and again, look, we're not here trying to convince you, sell any product to you, but I think my goal certainly is to share a little bit of the experience in the financial services world and tell the players in the world, right? I mean, their triumvirate is banks, fintech, and consumers, right?
Yep.
We're sort of OEMs, vendors, dealers, right? That's our triumvirate, and so it's similar in a sense. It's different. But it seems to me, I talked about the Arizona statute. That Arizona bill will require third parties accessing data to make it available via an open API. That's in the law in Arizona today, and maybe in more states as they come. The theory there,
Yep.
Which I think is consistent with what you're saying, is that that not only promotes security because it allows you to control and know and have visibility into what's happening with the data, and maybe someday with blockchain you can figure out even where it goes down the line, right? But it also allows anybody that has the next best idea in our industry or as the next best feature or integrates with financial services or wherever it is to also play and integrate with that same data, right?
Yes, and do so securely and that's customer permissioned. And again, we've solved a lot of these issues around, well, how does customer consent, the user experience flow, what is that meaningful? So when you have the consumer groups on board up front, we've already solved a lot of these things. And there are nuances to each business, mind you, but learn from us, please.
Well, and you said something that was interesting to me. I mean, I don't have any way to know, but the captives and the auto finance space, we've got AFSA, who's a group of financial services companies that meets in conjunction with our show because obviously the dealers are their clients and the OEMs are their partners and our dealer partners. Are they behind the times in this area? Or are they and I guess ultimately I'm trying to think to myself, you all have thought through this.
Yep.
You've addressed it for a very important sector. How would that translate to us, if at all?
Sure.
In the auto space.
There's two parts here. I mean, I mentioned scraping's been around since the mid-90s when Yodleys came up with it, and that's great, and still 3/4 of the volume out there is still done via scrape. We're slowly migrating off. Just like when you got your chip card, they didn't throw away your stripe cards overnight. It took a while to finally get everything out. But what we're finding is by lowering barriers to entry and having a lot of eyes on the spec, One, we found that it's very clear it doesn't make any markets for anyone. Two, we find things. I had somebody reach out on LinkedIn and said, hey Don, your latest version, I found a typo. You didn't capitalize something. Technically it's true, so we made that change. By having literally thousands of people looking at this thing and having it open, you are QAing it. And you're not locking in, there's no vendor capture, there's no manufacturer capture. That's important.
Well, and you said a few things that I think are important, and you went through that quickly, but that's okay. No, you lived this more but slow down for a slower person like me. What I think I heard you say is it's open in the sense that the people building the tool are the people in the industry, right? So right. It would be OEMs, captives, vendors, and others building the tool for the auto space.
You have to have both sides, the senders and the receivers. One, the line's blurring, but two, you can never have any one group, setting the standard without the end receiving party also having equal say. And then usually we have a supermajority required for everything. You need that for a variety of reasons. If you guys remember, IBM used to have a lot of proprietary standards. It was eventually beaten out by open standards. And if Big Blue can't push something in the tech space, what are the odds of proprietary standards working long term anywhere else?
Well, and you also said something that obviously is near and dear to my lawyer heart, which is one of the reasons the financial services firms got together and did this, even if they thought it may be an expense or an effort that they didn't relish, was they did it to get in front of the regulators telling them what to do. And obviously, if there's nothing else you heard from me today, is we've become the focus of an intense regulation. I'm just looking around saying, sure, might behoove us to get out in front of this.
Absolutely.
As an auto ecosystem.
When the CFPB put out their proposed rulemaking last February, there were 100 responses. FDX was mentioned in roughly half of them. It's, hey, this is what we're doing about it. You don't need to do anything. We've got this. We've got the tech. Don't worry about it.
So slow down. So what you were saying is, when the regulators came knocking, the people who were about to be regulated say, wait a minute, you don't need to regulate me because I'm doing this already.
We're doing this.
Right? This is the prophylactic. And I tell you, sitting in Washington, it's very important. The OEMs in the room will probably know when the OEMs, when they have to testify on Capitol Hill, they talk about the Auto ICE Act.
Yep.
They talk about the privacy principles that they've adopted. And it would be nice to talk about something like some open standards potentially or open API standards, because it's a real tool that gets out in front of the bad guys, right?
With real metrics. Even if you just have a consumer pilot and with friendlies and get started. Hey, I'm making progress in this. I've done this. I've committed this. So you have real things you can point to. You can point to data sharing agreements. And so you have this nice dossier you can then take to regulators and lawmakers that, look, we're making progress in this, and we're solving this. We've got this. The other thing, again, DEI is so important. When you lower the barriers to entry for new entrants who can then compete on best idea and not have to have a bunch of staff, I think it's helpful. We have a one firm, one vote policy in our group. So, Visa and MasterCard are sitting across the table. Don and his fintech, I have a cool idea for a new data element. If I'm persuasive and I convince everybody, I have the same vote as Wells and Citi. And so that's powerful. And so that's a great selling point as well for your DEI programs.
And again, to expand on that, I think I'm following you, but what you're saying is basically, again, for the people like me that don't live this every day, is by establishing this standard that anybody that's open, in the sense that anybody can see it, and essentially whatever effort it takes to write to it, you can write to it.
Absolutely.
If there's a cool new feature, software, device, whatever it is, you can insert it into the auto ecosystem in a much easier fashion because
Absolutely.
you can write to the standard, right?
Absolutely. Now, again, anyone can see the spec, anyone can have it, and we let you have a license to use it royalty-free commercially at any volume. Great, God bless. If you want to change the spec, we do ask that you join for a couple reasons. One, primarily for governance. Any change you make has ripple effects through the ecosystem, so we want a lot of eyes on it while it's being developed, because we don't want to write something that, it's about to be deprecated by NIST or something else. So we have that governance. So we do ask that you join. It's relatively cheap. The smaller you are, the less you pay. But that's typically how it's done globally, and it's been very successful.
Well, and just to be clear to those in this room, you're not
selling.
selling the product, right?
No, it's free,
selling
for God's
anything,
sake.
right? It's basically what it is the folks in the industry have gotten together and through a membership model have said, let's get together as members and make this tool that we can all use, again, to get information from A to B to Z in a secure fashion that also incorporates the best features, right? Again, in our world, you touched on it, but I've heard this a number of times. People will want to make a payment through their dashboard, right, or whatever it is. There's something as simple as that. Mm-hmm. Probably today, I worry about that because in our space, frankly, I'm not sure how much we have the integration we need between the car, dealer systems, OEM systems, and then the pipelines that it has to go through, right? Whether it's over the air or otherwise. It sounds like this solves that problem, but it requires what? Adoption by the people in the industry? Is that the magic sauce?
Yeah, this is the magic sauce. Just like the USB cable or top fob I showed you. It requires adoption, or like Windows. Everyone's on it because everyone's on it. You have that networking effect. And the gentleman asked about security checklists. Well, if you've got this standard in place, it solves a lot of those. Are you using the spec? Are you using the biometric recommendation? Are you using the data at rest? Are you using encyclical encryption versus polymorphic encryption? Whatever. There's a lot of things this solves for you that you can then very quickly, very defensively say, nope, I'm doing the following. We're good.
You went the direction I was going, because again, if there's messages you've heard from my perspective, as I've been thinking about this safeguards rule in particular the last few years, it's all the, for an individual dealer to address all these things individually with all their OEMs and vendors will be very difficult, right? Multiply that by 18,000 by however many thousand vendors there are plus 30 OEMs, it doesn't take long to see it's going to be impossible, right? So I'm always looking for ways to, whether it's sample contract terms or sample InfoSec questionnaires or whatever it is, to make, even if it'll be a little painful, more painful for everybody than nothing, it'll at least be better than having to do it 10,000 times. I think I'm hearing you say this would address a number of those areas, because you could then say, well, we're using the integration. For example, when I said access controls, was one of the things you have to do. If you say I'm using the API, that has access controls as part of its functionality, right? So,
Absolutely.
So you could check off some of these boxes by doing these things, right?
Yeah, and I won't get into the weeds. I promise I wouldn't use any acronyms, so I wouldn't. But yes, we absolutely have best-in-class access control, and I can prove out why. It's NIST happy and all that good stuff. But the important lessons I want you to have is, one, don't do this alone. Two, copy from us. Financial services has been in the brunt of this for decades now. Please see what we've done. And three, work together through your ISAC, through NADA. Again, I think we're stronger together. Think about that truck image I just showed you. What if you took that red container off of it and put a blue container on it, so it was dealer info instead of credit card info? It's really, in some ways, that simple. So if you were able to leverage the FDX rails, you're already there. You're just changing the containerize.
And there's a question. Go ahead.
Yes, ma'am. Oh, yes, sir.
I have three separate questions. I guess first to Don, so this API you're speaking of, is it STAR compliant?
I'm certain for the recording, the question is the API STAR compliant? And I don't know if you know the answer, I can weigh in if you don't, but STAR, for those of you who don't know, and it's actually something that's worthwhile knowing, stands for the Standards for Technology and Auto Retailing. It's been around for a long time. It's an organization that exists. My understanding is they are working on APIs, but they're mainly in the XML space, and they're the JSON, which is sort of what they've done. Is they've said, okay, let's at least get a standard. If we're going to give a RO, it's going to be name, address, VIN, part number, rather than part number, address. They basically formatted the data packets that have gone back and forth, but they don't have the APIs yet, but they're working on it. So, one thought is maybe some synergy between what FDX has done and STAR, but that's a great question.
Yeah, STAR or auto extension onto our existing API, I think would be a natural. Then it's just a data dictionary.
The other electric question, Brad, or you, sir. Okay, so of you talked about violations. There was 46K violation. Is to differentiate that from CCPA? Is that per record or is that per violation?
Sure. And the question for the recording is asking specifically about the FTC penalty, 46,000, whatever it was, per violation. The answer is I'm not sure, because they could measure it however they want. All right. A violation of the safeguards rule is what? If you violate the access controls piece, is it per record? Is it? That would be ridiculous, because it would immediately be $200 million per time. But so I don't know. It's not been tested yet. But remember, the FTC, I want to be clear, I never want to overplay the FTC penalty authority because, as I mentioned earlier, there's a governor that the Capitol Hill put on the FTC 40 years ago, which says they have to first bring an enforcement action and then get a consent decree against you saying, I promise I'm not going to do that bad thing again. And then you have to violate it one more time. That actually happened in the dealer space in the advertising world where they got a consent decree. They then had some bad advertising or alleged bad advertising, had to pay a big couple $1 million fine. So those big penalties are big, but they don't kick in until the second time around. That's a huge problem. For the FTC is always at Capitol Hill asking for the ability to do it the first time, but they haven't got it yet. So. Is there some grace period? Is the question? Not that I'm aware of. There's no right to cure. There's only a warning in the sense, like I said, they'll come. Not that the consent decree is free, because they're very expensive and they're 20-year consent decrees and they're very onerous. But they won't have the authority to issue a monetary penalty until the second time. But again, to me, that's why I mentioned the fact that I think the real risk in the deal world is the state law, the piggybacking of the safeguards rule onto a state class action or some other way. Again, I didn't mention this, but when we met 2 years ago, it was still hard for a plaintiff's lawyer to prove damages in a breach case because courts were just saying, where's the harm, right? You can't really have standing because it's sort of too existential, this right to privacy. Well, that's really changed. I mean, courts are really accepting. Plaintiffs' lawyers are pretty easily able to get over that first or initial burden of saying, if there's a breach, yeah, there's going to be harm, which is why you're seeing these big settlements on these breach class actions. So hopefully that helps.
Last question was about the InfoSec questionnaire. Who's responsible for that questionnaire?
And the question is, InfoSec questionnaire, who's responsible for it? Okay, again, the dealer is the financial institution responsible for compliance with the rule, unless you're a finder. Well, this is all these caveats now that come out here. But they're going to be sending, my sense is they're going to be sending anybody who's a service provider, anybody who's touching their data, a questionnaire that says, are you doing all these things, right, as an initial step. I can tell you, we used to have, as you may know, we used to own the NADA used car guide company. I was a lawyer for NADA. We had clients that were banks and financial institutions. We got those things all the time. And they're 200 pages long. We had an employee that did nothing but that all day because they're onerous. But they've been doing this for a long time in the financial services world. My sense is that's the kind of thing. Who's responsible? The dealer's responsible for getting the answers to that so they can then fill in those written documents I told you about. So, but there's also an argument that says basically you'd be as the recipient would have to give them the information they need for them to do business with you. So that's the.
So with more specifically the question is who is responsible for those InfoSec questions?
Oh, okay. And the specific question is who's responsible for sort of putting together what's on the questionnaire? Well, again, it's one of the things. And we're not putting all this on our plate because we think we're smarter than anybody else, but we're a central location for doing that. So we're putting out some templates that we think. Again, the theory is if you can do it once and do it right, it'd be better for you all to do it once and do it right than have to do it 4,000 times. So even if we come at you with something and you say this is really onerous, at least it's just once, right? And then hopefully in a few years everybody's at the show with their InfoSec questionnaire and their audit, their standardized audit, and maybe even the Open API certification. That's ideally what I see in 5 years or 10 years in our world, is a way to accomplish all these complicated things in a more efficient fashion that also, again, we're the dealer advocate. We want to make sure they're compliant. They're on the hook. So we're going to make sure it's at least at the level of, it's at the minimal level of compliance at the least. And that isn't going to be easy. But I think it's going to be easier than doing it, like I said, 4,000 times.
Brad's spot on. So in financial services, we had some trade groups got together. So the Bank Policy Institute eventually created the Cyber Risk Institute. You have our ISAC that does those. Even have especially like the payment card industry, PCI. And now it's the coin of the realm. But I remember when PCI was getting started, regulators were like, I don't know, it's industry written. I don't know if we should trust it. Now it's a DSS, no big deal. And so you're seeing that getting started. So I think the Auto ISAC or NADA pull together the CISOs, the Chief Information Security Officers from the respective parties, get it together, kind of draft what you guys think are, stay with principles-based and thematic. So it can, if you get too prescriptive, too granular, it'll be wrong quicker. It'll get staler faster. And the other thing is, though, it will change as the new exploits come out and new bad guys pick up new stuff. You have to change it. So you don't just build it once. You have to keep going.
You know, and it just reminded me of something I didn't even mention. I mean, you know, look, and I alluded to this, but you know, there was the FTC came out, I think it was a month or two ago now, with a notice about what is it, Log4j?
Log4j, absolutely.
You know, and they basically said that, and if you don't know what this is, apparently it's a widely known vulnerability called Log4j. And they said it was so widely known that if you did not remediate for it immediately, that you know, basically were in violation of not just the section for the UDAP, the Section 5, but also the safeguards rule and everything else. And I'm thinking to myself, really? I mean, how many dealers are in a position to be monitoring at this point in time for Log4j? So one of the things we've done in the guide is given them some websites they're going to be checking. My point is saying, to Don's point, it's not just it's not just the bad litany of bad news I gave. It's even more than that, and it's going to keep expanding as time goes. And I think, you know, and this is one of the reasons I wanted you all to hear a little bit from the financial services world was, you know, think about if there were an open API common structure, you know, you do have the ability to then point to, I mean, the InfoSec questionnaire would probably go down by half because they don't anymore have to ask you for data mapping, or they don't have to ask you for access controls or all those other, some of those other things to confirm, because you say, yeah, I use this open API standard, which has that all built in. So these things all sort of fit together, and hopefully you're seeing at least why. You know, I've asked Don to come in and talk about it because that's going to take some industry-wide action. It's a great question. In the short term, the answer is we're going to do our best to give dealers something, and we hope not to inundate you all either. I mean, dealers are going to have a hard enough time. You know, as Don said, you don't want to be having someone, you know. I'm going far afield, but we have a dealer member who has stores in Europe subject to GDPR. Right? Big dealer member. They have 3 full-time employees. That's all they do, right? You know, we're trying to avoid that sort of complete inefficiency of doing things and bespoke 18,000 times for dealers if we can. But for now, all we know is 18,000 dealers have to comply. So we're going to give them as much as we can. So, yeah. Yes, sir.
Yeah, so a couple quick questions here. So as it relates to the FTC, I think you kind of went there with your last statement. You know, that's obviously a U.S. rule. Is there something similar going on today in Canada? And are they updating PETA? Are any of the rules there? Are you aware of that?
There's been some talk.
And for the recording, the question is about Canadian law, which, you know, is of interest, but you know, I know PETA. It's an email-based rule, but if you have thoughts on that,
it is. The Minister of Finance is looking at actually establishing an open banking lead in Canada. Rumor is, again, for what it's worth, you know, probably next month or so, and so they're going to look at perhaps as part of that program, perhaps some adjustments to PIPEDA because it's gotten a little long into the tooth now.
Well, again, you know, you say these things, and I think I'm following 90% of what you're saying, Don. You're a smart guy, but remember what Don's organization's addressing. There's a consumer demand for a new technology in the financial services space, and it led to a fintech workaround that created issues for everybody, right? We have similar issues in our world, right? I mean, we've got a lot of people that want a lot of functionality, they want an integrated buying experience of their automobile, right? A dealer today doesn't know, you know, they don't even know how many miles are on the car when it pulls into the service lane because they're not necessarily integrated with the telematics data coming from the car. I want to bring this down a little bit to our world because to provide the integrated customer experience that we all want to give and that people get everywhere else, right? Today, and they expect as part of their car buying experience, we're going to have to find a way to get this information from A to B in some way. And the way we're doing it now is not necessarily working or the most secure way. Someone has invented a mousetrap that does it better. And so again, I appreciate you coming and sharing it with us, but I just think it's the kind of thing that we as an audit industry hopefully will embrace, whether it's through the STAR organization, through the Auto ISAC, hopefully with the help of some people in this room, because it'll help all of us. And otherwise, we're going to get trampled by the regulators who are going to enforce something on us we don't want. So, yes, sir.
Last question here. So you alluded to it as well about an organization that does business in Europe and they're subject to GDPR. There's a lot of dealers that obviously have stores over state lines, so they're going to have different rules in regards to the different states. So we'll have to have obviously people focusing on that.
Sure.
Do you ever envision, and this is just a thought, of the U.S. stepping in and saying, let's create something similar to GDPR? So we don't
Yeah, the question is what do we think about federal privacy legislation to avoid the patchwork of state laws? I mean, maybe it's if I had to look at my crystal ball, the conflict is between privacy has become a little bit of a bipartisan issue, but what's not a bipartisan issue are the sort of the private rights of action and the ability to sue someone for violations of this, and that's a fundamental problem, because what you see is, like I said, I always use there was a number that came to that, and it's probably one of your members, so I apologize, but a very large bank who spent $750 million a year on cybersecurity still had a breach, right? There's basically no way to avoid having a data breach 100% of the time. We were talking the other day that it's like the club, right? I mean, remember the club that you put on your car? It doesn't keep anybody from stealing the car. It just kind of keeps you. It makes the thief go to the next one, right? And so there's no way to do this perfectly, but yet enforcers and plaintiffs' lawyers will come in after the fact and seek to hold you liable for something that there's no way you could prevent. It's like, you're a bank that got robbed and then you get sued because you got robbed, right? It doesn't seem to make a lot of sense. So that's the fundamental divide, is the one side of the aisle sort of wants to enact the army of private litigators to enforce this. The other side says it's crazy. You can't sue a business that's trying to do its best to protect it that got victimized by a breach. So that's the holdup at the federal level, and that's what the states are going to start deciding. On the other hand, when there are 20 states doing 20 different things, the business community will probably scream and say, come on, I don't know how bad it'll be before we have to have federal legislation. So yes, sir.
This one goes back to the SOC 2. Did the FTC provide any reason why they wouldn't take those annually?
The question is, what did the FTC, when I mentioned earlier, that we had asked in our comments whether we could just accept the certification for the third-party audit or for the third-party review, and the FTC said basically no. And the question is, did they give a reason? No is the answer. They didn't. They just said we don't think it's enough. If I had to guess, it's probably because when you look into all the requirements, there are some things that even SOC 2 compliance wouldn't help with. So for example, promises about, if I'm sharing data with you, the dealer is now going to have to get something in the contract that says, okay, and frankly, they always should have had this, just by the way, and not just because it's a good idea, but because they're required to under the privacy rule, likely, a provision that says you won't share that information with anybody else except to provide the service or something along those lines, and you'll only use it to provide the service. Well, that's not necessarily a SOC 2 compliance thing, right? So in other words, SOC 2 is relevant, but it may not meet all the requirements that the dealer has to meet them. Yeah, I mean, I don't want to suggest it's meaningless. I just wanted to highlight the fact that I've heard from many people like, oh, that's fine. We're SOC 2 compliant, so we'll share that, and that should check that box. And the FTC has explicitly said it probably doesn't. So I'm just sharing that because I know over the next 6 months, when that back and forth goes back between dealers and vendors and OEMs, we're just again bearers of the bad news. I think there is a bit of a legitimacy to the underlying purpose for that, but of course the part that is not realistic is that every dealer in this country will be having an IT audit of all their vendors. I mean, the example we gave the FTC in our comments was a cloud service provider, right? I mean, you can't even negotiate any terms of a cloud service contract, much less, by the way, Amazon, I want an IT audit, third-party IT audit of your security practices. So, and so I don't know. The answer is I don't know. So we'll see. I think this will get ironed out over time. All I can say is, if you ever want to be really bored, you could read my comments that were about 70 pages long, where I asked them all these questions, and then they, in fact, in the final rule, they mentioned NADA about over 100 times, because they were answering sort of all the questions we had all about this stuff. So, we tried. But this, again, that's why I wanted to give you some background on the politics, because I think the reality is they're just doing, they are doing what the legislators are not doing to that question, which is sort of creating a de facto, rule. And I didn't tell you that the most exciting part, there's still a pending rulemaking, believe it or not, where the FTC is saying, by the way, if you have a security event, which is ill-defined, it could be almost anything, successful or not, you have to report it to the FTC. So for the purposes of us enforcing the rule. So there's a pending rule right now, and we've submitted comments saying that's relatively unprecedented that you're asking us to self-report a potential violation of the law on ourselves, but that's pending right now, and that may be coming. So they are very aggressive in this area, and again, they tweaked it around the edges based on our comments, but they clearly, the political will is to move forward very forcefully on this issue. So.
One of the things I'd look at doing is some sort of industry safe harbor. If you can get a kind of an industry scorecard or an industry set of best practices, and the principles are a great start. And I love principles-based rules because they allow for variations based on the nature of your business and the nature of your size, your data, whatever you're doing. But the extent that you can have strength as a group, there's security in numbers, and have that as a safe harbor, I think it's defensible, and then it's a lot easier. And if they've got a SOC grade or an ISO grade, it probably takes care of a big chunk of that questionnaire. But it still gives you something. And hey, if everyone's met this bar, I think that's very persuasive, even when someone's trying an action.
So yeah, thank you very much. And I haven't checked the time. I think we're doing okay on time. Yeah, we're almost up against it. So look, you guys have sat here for a long time. We appreciate you coming here early on a Thursday morning. Again, from NADA, on behalf of NADA, I do want to thank you very, very much. The fact that you're here, you care about this issue, I'm sure you're trying to do the right thing, not just for the dealers. The dealers are going to be really, really relying on their vendor partners and their OEM partners for help with this stuff. There's no doubt about it. They look to us for the sort of the nuts and bolts of how to do it, but for the actual doing it, they're going to look to you. And so, I know this isn't going to be a particularly easy one, but hopefully next time we get together, which whether it's next year or whenever it may be, we'll look back and say we've addressed this in an efficient manner. So we'll keep working on it. Stay tuned for more. Again, if you have any questions, feel free to reach out to me anytime. And Don, thank you so much for your time.
Thanks for
Thank
having
you.
me.
All right, appreciate it all.
Good
Have a
questions.
great show. Thank you very much.